Hello, and welcome back to Chapter 10 in Healthcare Law and Ethics. We're still talking about the privacy rule, and we're moving on to Section 10.2, which starts at the bottom of page 210. And we're talking about HIPAA applicability. So we're talking about the first element of who and the second element of what. So who does HIPAA apply to? Well, it applies to covered entities and their workforce, and business associates, their workforce, and their subcontractors. What does it apply to? Well, it applies to protected health information. Now, it does exclude de-identified information, which we're going to get into as we flip the page. Privacy rule, there's defined identifiers, and it's going to exclude personnel and educational records. So let's get more in depth on who our covered entities are. Well, first of all, covered entities are one of three types of entities. So you have healthcare providers that conduct certain transactions electronically. So these could be hospitals, pharmacies, physician office practices, long-term care facilities, clinics, okay? And transaction examples are health claims and encounter information, health plan enrollment, health plan premium payments, coordination of benefits. And you can see a full list of that on page 211. Okay, our next covered entity is the actual health plans. So this includes any individual or group plan that provides or pays for the cost of medical care. And our third are the healthcare clearinghouses. Now think about a healthcare clearinghouse as being the bridge between the healthcare provider and the health plan. They are the ones that are processing the billing transactions between your healthcare provider and your health plan. Now, let's get into our business associates over on 211. Now, a business associate is a person or an organization other than the member of a covered entity's workforce that performs functions or activities on behalf of or affecting a covered entity that involve the use or disclosure of individually identifiable health information. So we cover this in health records again. So remember, a business associate may not necessarily be a cleaning company that comes in to clean patient rooms. They may be a business associate in the truest sense of the word because you may have a contract with them. But in HIPAA world, a business associate is actually accessing your individually identifiable health information, okay? So a contract company that does backlog coding, they are accessing your health records to code those charts. They are a HIPAA business associate. A transcription company that you have to fill in when you have a backlog, they're accessing your medical records. If you use a pre-billing coding company to look at some of your cases before you actually send the final bill out the door, they are a business associate. They are using your individually identifiable health information to complete a function for you. Now, so with that, we talked earlier in the first section that HITECH came along and actually made some significant changes to the privacy rule. It says in the bottom of that section that per HITECH, a business associate's subcontractors are business associates under HIPAA if they require access to an individual's protected health information, regardless of whether they have a business associate agreement actually signed. So they actually tightened up the restrictions on business associates. It says higher up in there, the business associate definition specifically includes patient safety organizations, which receive and analyze patient safety issues, health information exchanges, and health information organizations, which share health information among providers electronically. So again, anybody that is going to access health information, individually identifiable health information, they're going to be classified as a business associate. Now, this says in the bottom paragraph, once your covered entity identifies a person or an organization as a business associate, then the covered entity is obligated to initiate a business associate agreement, a BAA. And this is done to legally protect information that is handled outside of the covered entity or that it's handled by the business associate. You may have consultants, you may have billing companies, accounting firms, again, those contract coding companies. So anytime that they are performing a service for the provider, there should be a business associate agreement in place. Now, it says, in the business associate agreement, the business associate agrees to comply with the covered entity's requirements to protect health information. Now, in other words, the business associate must agree not to use or disclose information in ways that would not permit, that the CE would not prevent, and must agree to protect patient information from unauthorized access and disclosure. All right, flipping over to 212, you actually see some of the BA contract specifics and things that should be in there. So let's look at a couple of these. Prohibits the business associate from using or disclosing the PHI for any purpose other than that stated in the contract and pursuant to the privacy rule and minimum necessary standard. So if they use the information in any way, shape, or form outside of what's outlined in their contract, then they're in breach of contract. Let's look down. Clarify that the business associate is responsible to report breaches of unsecured PHI. So it is up to the business associate to report breaches. In the past, that really didn't happen. But when HITECH came along, that became a big thing, that now that business associate was pretty much on the same level as that covered entity, and they have to comply with all of those same regulations and safeguards as a covered entity. All right, over on 213, let's look at the text there. So under HIPAA, as originally written, a business associate was bound to the law to virtue of its association with a covered entity. HITECH changed this by directly requiring organizations or individuals meeting the definition of a business associate to comply with certain provisions of HIPAA, including breach notification and restriction on the sale of health information, and subjecting them to the same civil and criminal penalties that covered entities face for violating the law. This is the case even if a business associate has not entered into a BAA with a covered entity. Business associates must also comply with the administrative, physical, and technical safeguards of the HIPAA security regulations, along with the policies, procedures, documentation requirements imposed by the HIPAA security regulations. So again, it kind of put them on that same level. And in the past, where your covered entity was historically required to respond to their non-compliance, HITECH requires that business associates respond to covered entity non-compliance by reporting corrective action or severing the relationship with the covered entity. So it's kind of a two-way street now. You know, a long time ago, covered entities were more the top dog, and what they said went because the business associate was doing work on their behalf. But now, if the business associate knows that there's non-compliance with the covered entity, then they have an avenue to react to that as well. All right, so let's get into the definition here of our, and it's not in our slide deck, so I'm just kind of flipping through here. We've talked about a good bit of these things in the slides already, but let's talk about protected health information and what that definition is. So on 213, the privacy rule safeguards a category of information called protected health information. That's our PHI. To be PHI, it must pass a 3-part test. Now, that's going to be on our subsequent slide here. Shown on a subsequent slide. I haven't seen that. It says, I think they lied to me. So anyway, back to our slide here. So on 213, it gives us the part of the test, the 3-part test. So 1 It either has to identify a person or provide a reasonable basis to believe that the person could be identified from information given. So we may have some demographic information going on here. So we may have a social security number, a date of birth, something like that. Then it also has to meet the second and third parts of the test. So it must relate to one's past, present, and future physical or mental health condition, the provision of health care, or the payment for the provision of health care. And it must be held or transmitted by a covered entity or its business associate in any form or medium, including electronic, paper, and oral forms. So if you can see in 10.3, the figure there on the bottom of 213, that's the test for determining whether or not something is PHI. So it can identify the patient. That's the first thing. If it cannot identify a patient, then it fails the 3-part test. But if there's any way, shape, or form you can figure out who that patient is based on the information provided, then it meets number 1. Then it has to also meet number 2 and number 3. Okay? All right, flipping over to talking about the de-identified information. So we know that de-identified information is information from which personal characteristics about the individual or the individual's relatives, employers, or household members has been removed. Okay? And again, neither identifies nor provides a reasonable basis to believe it could be identified. Okay? So de-identified information cannot later be constituted or combined to re-identify an individual because you have nothing. You have nothing that allows you to figure out who that patient is. You don't have a name. You don't have a telephone number. You don't have a medical record number. You don't have account numbers. You don't have biometric identifiers. You don't have any of those things. Now, a covered entity can remove certain elements to ensure that a patient's information is truly de-identified. Now, there are 18 elements, okay? This is called the safe harbor method. Now, if these 18 elements are removed from electronic information, then that patient information is truly de-identified. Okay, so it's on our next slide, and it's on the bottom of page 214. So again, name, geographic subdivisions, or the specified size. So geographic subdivisions smaller than a state, that would include your street address, city, county, precinct, zip code, anything like that. Okay. Number 3, dates. All elements of dates except the year directly related to an individual. So we could be talking about a birth date, an admission date, a discharge date, a death date. So if we get rid of all of the dates that would help us figure out how old that patient is, what time they came in, then we're good. Telephone numbers, fax numbers, any email addresses, social security number, medical record number, their health plan beneficiary numbers, account numbers, their certificate or a license number, vehicle identifiers, device identifiers, any URLs, any internet protocol address numbers, so your IP addresses, any biometric identifiers. You got to get rid of any photographic evidence of the patient and any other unique identifier specifically for that patient. If all 18 of those things are removed, you've met the safe harbor method and that patient information is truly de-identified. Okay. Now it says the covered entity can have an expert apply generally accepted statistical and scientific principles and methods to minimize the risk that the information might be used to identify the individual. Because it talks about, if you read over there on number 2 and number 3, that you can actually make some changes in there, especially if you've got like a zip code. You may change the first 3 digits to a 000, or zip codes with the same 3 initial digits could be combined. You know, you can figure out ways to kind of take care of that. Now it says, what if this covered entity needs to re-identify the information? Well, in other words, how might the entity match information back to the person it identifies. The privacy rule allows an entity to assign a code to de-identified information to allow for re-identification. Now, it says in doing so, the entity must ensure that the ensure that the code assigned is not derived from or related to the information about the patient and cannot be translated to his or her own identity. So, you can't come up with a code that might be my first initial, my middle initial, my last name, and my date of birth. That's just not going to cut it. So that's very easy to identify who that patient might be. It also has to ensure that the code is not used for any other purpose and does not disclose the mechanism for re-identification in any way. So there's something about that code that may be just completely randomized. Tiffany Tubb could almost become XY Z1652. None of that information has anything to do with me as a patient or as a person, but anybody looking at that, they're not going to have a clue that that's related to Tiffany Tubb. All right, and then let's talk about health information in personnel and educational records. Now, although a person or an organization may be subject to the privacy rule, not all information that a person or organization holds or comes into contact with is protected by the privacy rule. It says, for example, the privacy rule specifically excludes employment records held by the covered entity in its capacity as employer. So, under this exclusion, employee physical exam, they may be contained within a personnel file. They are specifically exempted from the rule. Also, education records, including your grades and disciplinary records, but also health records or that can be collected by the school, they're covered by a different rule. So they're covered by the Federal Education Records Privacy Act. It's called FERPA. And it's also excluded from the privacy rules definition of PHI. So the school can have the information, and it's not covered by the HIPAA privacy rule, but they have their own rules, they have their own HIPAA called FERPA. All right, so let's look at the check your understanding. I feel like I've kind of been all over the place in this section, so bear with me here. This is harder to do from home than it would seem, but so let's look at check your understanding. So number 1, a hospital employee's pre-employment physical exam is in his personnel file in human resources. This report is PHI. That is false. Remember, it does not fall under the privacy rule. These are excluded. Number 2, a covered entity need only consider its employees when evaluating HIPAA compliance within the organization. That is also false. If you go back to page 211, it lists out the workforce. So they're not responsible just for employees, they're responsible for the workforce, which consists of employees, volunteers, student interns, trainees. Okay, number 3, de-identified information receives privacy rule protections. That is false. If I've got a whole bunch of diagnoses listed out, and I've got procedures listed out, and I've got an explanation of all of them, the information really doesn't mean anything. I can't tie it back to a person, so again, it's not individually identifying a patient, so therefore it is not covered by the privacy rule protections. Number 4, in part, information must be individually identifiable to meet the definition of PHI. That's true. And then the last one, a business associate is anyone who might have access to a covered entity's PHI. And again, that is true. In HIPAA terms, a business associate is someone that is going to access your PHI to do some kind of business for you, with you, etc. So, a cleaning company that comes in and cleans your office, they may be a technical business associate because they come in and they have a contract with you to perform a service, but under HIPAA terms, they're not a business associate because they are not accessing your health information. All right, so again, I didn't read every word of this section. Be sure to go back through this section 2, starting with HIPAA applicability on page 210, and I will catch you in section